So as I've said before, there are two requirements: entry requirements, that 21 years old at least, then the academic qualification, now the examination requirements. All right, these are the professional requirements that the MAS require a person to have, to undergo, to pass. Like Module 5, for example, is a good example. All right. And then whose name is entered into the public register is the same thing as I've told you earlier. And of course, the status has not been revoked or suspended, and there's no prohibition order by the MAS against that particular person. All right, and so on. And of course, F is important. The principal must be licensed for that type of financial advisory services. For example, if the Financial Advisor Corporation is licensed to do collective investment schemes, all right, so therefore the provisional representative will have to give the financial advisory services regarding the collective investment scheme. He cannot do something else like arranging for life insurance or investment-linked policies, right? So it is in terms of the capacity in which the provisional representative can act, and in what type of product, what type of financial advisory services. Right? And G, who has not previously been appointed as a provisional representative by the MAS and is not disqualified one way or the other from acting as a provisional representative. So in that regard, that's a criteria. And you will notice that the criteria is slightly different from the appointment of an appointed representative. Right? If you do a comparison, right, look at paragraph 11. Those are the criteria for an appointed representative. So if you are Singaporean or a permanent resident, all right, you want to apply to be appointed representative, you got to look at that criteria. All right. Under paragraph 11A, 11.1 to 11.2. Right? But if you are a foreigner, all right, and you want to relocate to Singapore, right, and to work in the financial advisory sector under the FAA, then you need to look at 12.1. Okay? And of course, this will have some relevance also to the Financial Advisor Corporation or the exempt financial advisor. If you want to appoint a provisional representative, all right, the Human Resource Department or the recruiting unit of the financial advisor will have to look at the criteria under 12, A 12.1. And 12.2 is again a repeat in terms of the FAA to be read in conjunction with the FAR. And the individual shall, note the word shall. The word shall in legal language means, well, almost compulsory. It is not may or will. It is a shall. So shall only be a provisional representative for a period not exceeding 3 months from the date his name is entered into the public register of representatives. Right, provided he passed the professional examination required. So he has this 3-month period to pass his professional examination. Now, very quickly, then B talks about the cessation of the status of a provisional representative. Again, I want you to compare that with 11.3 to 11.6, all right, where it talks about the cessation of status of an appointed representative. So again, there are some similarities. Again, there are some differences between the two, and you need to be aware of the differences. All right. Now, talking about differences, I refer you to paragraph 13.13, and there very clearly they spell out for you under 13.1 all the way to 13.4 the differences between appointed representative and provisional representative. All right. And 13.2 actually summarizes what I have just spoken to you regarding the appointment of a provisional representative. Now, 13.3, the second line is important. The provisional representative, I read to you, can continue to provide financial advisory services as an appointed representative. All right. So this provisional person can become an appointed after, I repeat that, after his principal has notified the MAS within the 3-month grace period of the representative's fulfillment of the relevant examination via a one-time lodgement form, Form 3D. All right, so if this provisional person, whether from Hong Kong or Japan or anywhere, all right, qualified to come to Singapore to work as a financial advisor representative in the financial advisory services industry, all right, then within the 3 months he passed a relevant professional examination under CMFAS, then he may be appointed then as appointed representative. All right, so that is the A part, 13.3A. And B, more importantly, his name has been entered in the public register as an appointed representative. All right, so the public register is important under the RNF, which I spoke about earlier. Now, for more details regarding the differences between appointed representative and provisional representatives, you need to refer to the FAS notice FAN 12. All right, so the details are provided in that particular notice, FAAN 12. Now, paragraph 14. Right? Paragraph 14 sets out the notification procedure. Right? So here it is more for the company, right? The Financial Advisor Corporation or the exam financial advisor for the company to do. So what are the documents that the company has to lodge? Right? So the principal who desires to appoint an individual as an appointed or even provisional representative in respect of any type of financial advisory services must lodge Form 3A and 3B. Now this is procedural, right? And MAS may prescribe from time to time. So they do change the type of forms and the type of requirements, right? Whether they need additional information or additional documents to be found. So for the time being, at this moment, they require the company to file Forms A3 and 3B. Now this refers to a notice of intent. So that's the first document to be filed, notice of intent by the principal to appoint the individual person as an appointed or a provisional representative. 2, you need to have a certificate. All right. So the principal has to to file a certificate so that the individual is a fit and proper person. Now we will come to that later on. As I've said, fit and proper person is very important in this particular industry, the banking and finance industry. And in the case of provisional representative, you need an undertaking. So the principal has to undertake such responsibilities in relation to the representative. All right. So end of the day, if you want to appoint a provisional representative, right, you need to have this undertaking by the principal. So just to recap, so you need to lodge documents that must be lodged with the MAS is a notice of intent, a certificate that the person is fit and proper, and in the case of a provisional representative, an undertaking. Right? That the company is undertaking responsibilities relating to this representative when he or she is relocated to Singapore. Right? And of course, he or she can work for a 3 months period, all right, provided he or she passes the professional examination under the CMFAS or other requirements. Right? Yeah. So 14.2 says that the same thing, all right? You have to inform the authority of the fact in the prescribed form and manner under that particular section of 23D5. And then 14.3 says the same thing. Notice that there are penalties involved if the principals do not file the necessary documents regarding the appointment of the appointed or provisional representatives. So this a procedural thing, a notification procedure. So the MAS is kept apprised of who are the people the principals have appointed, right, in regard to either appointed or provisional representatives. Okay, So Forms 3A and 3B are available on the MAS website. So Human Resources Department or whatever department in the principals can go onto that website for lodgement of the forms with the MAS. Right? Now B, entry into the public register. We have talked quite a bit about this one, so I do not want to belabor the point, and I just move on. Now C is another procedural thing under the notification procedure in terms of the retention period. All right. I mean, generally speaking, whatever you lodge or whatever the principal lodges with the MAS, there's a requirement for the principal to keep the records, to document and to keep the records over a period of time. Now, generally under the law, under contract law, the limitation period in Singapore is 6 years. This is a time bar period, right? Limitation period of 6 years. But in terms of the requirement, the retention requirement for the principal, 14.7 says that for a period of 5 years from the date of the lodgement. All right. So from the date you lodge the certificate, all right, you got to keep the documents in such a way that that the transaction or the transaction can be reconstructed, and this document has to be kept for 5 years. Right? If there are any changes in regard to any of the particulars of the appointed or provisional representative in any document required to be furnished to the MAS, the principal shall no later than 14 days after the occurrence of such event furnish such particulars to the MAS. So in this regard, there's a continuing responsibility on the part of the principal, right? On the part of the Financial Advisor Corporation or the exempt financial advisor. There's this continuing operation. Hey, look, if there's any change in the particulars, all right, the word there's any change, all right? And if there's any change, then the principal has to lodge, all right? She have to lodge or she have to furnish this change in particulars of the appointed representative or the provisional representative to the MAS no later than 14 days. All right, that means by the 14th day from the occurrence of the change, such a document must be furnished to the MAS. So the timeline is 14 days. And again, they provide you with the form that you need to fill in regarding change of particulars, and that's Form 18. And again, for 14.9, provide a penalty provision. If you fail to do that, all right, if you fail to comply with the notification procedure set out under paragraph 14, then shall be guilty of an offense. All right, so it's an offense. Now, generally speaking, if there's no prescription of the penalty, generally speaking, the penalty is usually 25,000 or a part thereof, right? Depending on the severity of the breach, and normally there's also a part thereof on a per day basis if the offense continues if the offense continues to be so. All right. So in this case, 14.9, there's no specification. So in all probability, the fine could be a maximum of $25,000. Okay. Now we'll talk about the undertaking of responsibilities earlier in regard to a provisional representative. Just to refresh your memory, if you turn back to A 14.1c, that is the undertaking we are talking about. Okay, so here at paragraph 14.10, it gives you the type of undertaking. All right. So I just read to you very quickly. A principal shall undertake, second line at 14.10, a principal shall undertake all the following responsibilities in relation to its provisional representatives. So A, B, C, D, E set out the responsibilities. 1, to put in place measures to properly supervise the activities and conduct of the representative, including measures to ensure that all obligations assumed and liabilities incurred by him are properly fulfilled, whether actual or contingent or howsoever arising in relation to the provision of any financial advisory services. So this is a provisional representative. All right. So while he's giving advice, the financial advisor corporation, or to put it simply, the principal, will have to make sure that measures are in place, right, to supervise this provisional representative as to the work he actually does. B, put in place measuring proper training, right, to ensure that the representative understands and complies with all Singapore laws that are relevant to the financial advisory services provided by him. For example, right, the anti-money laundering laws, right? For example, the personal data protection laws that has came into effect, right? So you must provide the provisional representative, who is essentially a foreigner, proper training in regard to the laws applicable to the financial advisory services, right? And C, make sure that this representative accompanied at all times by an authorized person as the appointed representative, director, or officer of the principal when meeting any client, and underline that, or member of the public in the course of providing of any financial advisory services. So there must be this undertaking, right? That somebody must be with him when meeting client or member of the public. D, I read to you quickly, ensure that the representative sends concurrently to any of the authorized persons or electronic mail that is sent to any client or member of the public in the course of providing any financial advisory services, right? So even when he sends out mail and what have you, right, so somebody must be supervising him, right, to ensure that the representative does not communicate by telephone with any client or member of the public when providing any financial advisory service other than by telephone conference, underline, in the presence of any of the authorized persons. So there are some limitations, right? There are some limitations under which a provisional representative can act. So those are the undertaking by the principal, if the principal wishes to employ a provisional representative, right? So A and E, they are pretty important. All right, if you are going to apply to be a provisional representative, right? If you are hired as a provisional representative, you have to make sure that you don't do some of the things which are restricted under A to E at paragraph D 14.10. And of course, the onus is on the principals themselves, the principals that hire provisional representatives, to make sure that they have all this in place, right? To supervise the conduct of the provisional representative in the course of their work, right? So the onus is quite heavy. You can see the use words are to ensure, and to put in place, right? So this is quite this is stringent. Okay, so that covers the appointment. That covers the meaning of representatives, appointment of representatives, cessation of representatives, and with particular regard to some of the responsibilities that must be undertaken by the principals in regard to the employment of provisional representatives. All right. Now we look at paragraph 15. Now here it sets out the power of the MAS to refuse entry, 1, revoke, 2, or suspend status of appointed or provisional representative. So regardless whether the principal has appointed an appointed representative or provisional representative, MAS reserves the power, right, to refuse entry, to revoke or suspend status, right? And this is set out in 15.1. Okay, MAS may refuse to enter the name and other particulars of an individual in the public register, or refuse to enter an additional type of financial advisory services, or to revoke the status of individual as an appointed or provisional representative. If A, B, C, D, E, and F. Now again, A, B, C, D, E, and F are quite commonsensical in terms of the person being a fit and proper person under the Financial Advisors Act. All right. So if you look at A and you look at, for example, A, C. Look at the A, B. Okay, look at A, for example. Okay, let's start with A. If being a representative, he fails or ceases to act as a representative. So that's failure on the part, or he resigns or he stops. So therefore, his status is revoked. Right? Or B, if he or his principal has not provided MAS with such information as required, so the MAS says, look, we don't want to enter his name in the register, and he's a bankrupt, right? The guy's a bankrupt, so MAS will say, hey, as far as I'm concerned, we don't want him to be our financial advisor representative in Singapore. Or if he has been appointed as a representative or even a provisional representative, and then he becomes a bankrupt in Singapore or elsewhere. Supposing this is a Hong Kong guy, right? Hong Kong person. When he came to Singapore, he applied to be a provisional representative, and his qualifications are okay. And then he has been appointed as a provisional representative, right? Subject to the 3 months where he has to pass his exams. So during that 3 months, say the second month, he became a bankrupt in Hong Kong. Right? Then of course MAS has the power to refuse to enter his name into the register. Notwithstanding, he may pass his professional exams after the 3 months. Okay? So MAS reserves the power to do all these things to make sure that fit and proper persons are hired, are employed to provide financial advisory services in Singapore. Right? E is quite clear. I say there's a typo error there. So it's undischarged bankrupt. That should be C. Then D, execution against him in respect of a judgment that has been returned unsatisfied in whole or in part. Now what this means is very simple. He may be a party to a civil suit, all right, and he is owing somebody some money, all right, and there's a judgment debt against this particular person. All right? And of course, when the judgment creditor tried to enforce the judgment against him, he cannot satisfy the judgment. All right? That means he failed, he cannot satisfy the judgment debt. If that be the case, then MAS may deem that he is not a fit and proper person, and either the MAS will refuse him entry, or if he has been entered into the register, then they can revoke the entry or to suspend the status until such time he repays his debt, and so on. Okay, depending on the facts and the circumstances why he did not pay off a judgment debt, right? Either in whole or in part. Now E is quite clear when he has entered into a compromise or scheme of arrangement with creditors. All right, that means he's in financial difficulties. He's not financially sound. All right, he fails to satisfy the soundness, the financial soundness principle under the fit and proper criteria. All right? Under the fit and proper criteria, a person must be financially sound. All right? So you're not financially sound, and you have this arrangement, scheme of arrangement with creditors or compromise still in operation, then you are deemed not to be financially sound. And if you are not financially sound, then MAS say, okay, we have to suspend or revoke or refuse entry. And of course, if you look across the page there, F is even more serious, convicted of a crime in Singapore under the Financial Advisors Act, or any act of fraud or dishonesty. So anything that has a bearing, anything that smells, of dishonesty, fraudulent conduct, well, that means that person is not fit and proper, and as such, well, MAS reserves the right, and there's a power to refuse entry, to revoke, or to suspend the status. Okay, now let's move on. Now 15.2 is even more encompassing, is broader. Right? So it says the power 15.2, the section 23J1G of the FAA says the MAS has the power to refuse entry into the public register all right, if MAS is not satisfied as to the educational or other qualifications or experience, having regard to the type and nature of the duties that he is to perform in relation to that type of financial advisory service. Right? So your educational qualifications or other qualifications may not be recognized by the MAS. All right, you may have an MA, you may have a degree from, for example, ABC University from XYZ country. All right, so MAS is not satisfied with your degree, so MAS say, okay, we don't recognize it, and then they say, okay, then we don't enter you into the register. So that's the first one. So they are very strict. MAS is very strict in regard to educational and other qualifications, or even experience. All right, you say I got 25 experience doing a particular thing. And if MAS has doubt as to the level and the depth of experience or the type of experience, then MAS say, hey, look, I don't think you have that type of experience or that scope or that depth of experience to function as a financial advisor representative in Singapore. So that's in terms of the power, the scope of the power of the MAS. Okay. B, as I've said before, is fit and proper. That's always the key. And then number C, not satisfied with the track record of past performance expertise. It's a bit similar to A. Now you're talking about his record of past performance or expertise, right? A talk about his educational qualifications, experience, and C talk about his past performance, right, and his expertise. He may be failing and not doing well, or some form of taint over his past performance. So and therefore MA is not satisfied. No, end of story. Say sorry, we cannot enter you into the register. And the last bit is the all thing. So either on one of the four. MAS has reason to believe that he will not perform that type of financial advisor services efficiently, honestly, or fairly. All right. So again, it has this bearing on honesty and fair dealing, right? So if this person comes from a jurisdiction, that is of a lower standard, for example, and MAS is not satisfied, so MAS will say, okay, we don't enter your name into the register, and therefore you cannot practice as a financial advisor representative for a particular principle. Okay. And 15.3 added an additional requirement for provisional representatives, right? Provisional representatives in particular, right? MAS may refuse to enter the name and other particulars in the public register as a provisional representative if, now I want to emphasize this point, if he is not or was not previously licensed, authorized, or regulated as a representative in a foreign jurisdiction, underline this part, for a continuous period of at least 12 months. So the MAS require continuity and some length of experience. All right. So if that a provisional representative, say a guy from Hong Kong, all right, or a guy from Indonesia or Malaysia or anywhere, all right. So if you have not been licensed, authorized, or regulated, okay, for a continuous period of at least 12 months. So only 6 months only. MAS will say, okay, no, this person doesn't qualify. It must be at least 12 months. All right. So if this foreigner want to come in and he has an experience, he has been licensed, authorized, regulated for say 15 months, or 3 years, or 5 years, then probably he will satisfy A. All right. Provided, of course, it's fit and proper and have all the educational qualifications and all that stuff. Right. So there's a lot of criteria to be met. And B, I again want to emphasize the period between the date of his ceasing to be sole licensed. Now, this is critical. The word is ceasing. All right. So let's say this person is a Hong Konger, all right, for example, or a UK citizen or US or anywhere. He stopped being a financial advisor representative. He stopped being a financial agent. All right. Stopped being licensed, authorized. All right. From the date of his cessation. All right, and the date of his proposed appointment as a provisional representative exceeds 12 months. Now, what does this mean? Now, this simply means that he stopped working, he stopped ceasing to be licensed, authorized, or regulated in, say, Hong Kong, for example. All right, And now he wants to be appointed as a provisional representative in Singapore. Now, from the date of cessation, that means stopping to be licensed, authorized, or regulated, and the date of being appointed as a provisional representative, if that date is more than 12 months, say 15 months, 13 months, 2 years, he stopped acting already. So that will not qualify him to be a provisional representative. In other words, the cessation period between the date of cessation, the period between the date of cessation, I repeat that, the period between the date of cessation and the date of the proposed appointment, all right, must be less than 12 months. Say 6 months, 3 months, then he qualifies. If anything longer than 12 months, MAS may think, well, we will not want you to, MAS may not want to enter the name in the public register. Meaning to say, the MAS will not approve of his appointment as a provisional representative. The reason being is too long. Okay, so 12 months without working, maybe you're not up to date, of the rules and regulations. You're not up to date in regard to the market and so on and so forth. So that there's this timeline of the period, all right? The period between the date of his ceasing to be sole licensed and the date exceeds 12 months. Okay. And of course, the third part C say MAS is not satisfied that the laws and practices of the jurisdiction under which the individual is or was so licensed, authorized, regulated, provide protection to investors. Right? Supposing MAS look at this person, this foreigner, and he comes from a jurisdiction, say XYZ jurisdiction. Right? And XYZ jurisdiction is well known, right? Where the laws and the regulations and the practices are not up to standard. All right? In terms of protecting investors, particularly retail investors. All right? So if that person comes from such a jurisdiction, MAS may say, hey, maybe we have doubts and we do not want to enter your name in the public register as a provisional representative. Okay? So that is 15.3 in terms of the additional requirements underlying for provisional representatives. So MAS, in other words, is very careful, it's very cautious to make sure that fit and proper persons are hired, all right, are employed to be financial advisor representatives in Singapore. Okay? Especially in particular to foreigners who want to come over to Singapore to work. They want to relocate to Singapore to work in the financial advisory services industry. Okay. Now, moving on to paragraph 16. Again, it sets out the power of the MAS to impose certain conditions or restrictions in terms of what the financial advisor representative can do or cannot do. All right. And 17 says about 4 statements in relation to notification. All right. So if anybody make any false statement, well, lo and behold, that person has committed an offense. Now, what I want to emphasize to you is at paragraph B, under 17.1 paragraph B. Omit to state any material matter without which the document is misleading. Now, a lot of people outside a lot of people in the industry seem to forget that omission to state any material matter is also considered as false and misleading. Now, don't get away with the idea that, oh, if I don't say anything, I omit, all right, then I'm not making any false or misleading statement. Now, that is wrong in law, especially if the omission is deliberate or willful, right? If you willfully or deliberately omit to make a fact or a statement or a matter, right, that omission will be considered as false and misleading. Right? And in that regard, you can look at the punishment. It is not exceeding $50,000. All right? That means the maximum they can fine you for misleading statement will be $50,000. So this will regard to the principal, which lodges the relevant reports, the certificate, the notice of intent, and the undertaking, or even the individual. Right? If the individual omits a fact or a statement or a matter that is material, considered material by the MAS, then that omission is considered as false and misleading. And in which case, the punishment is a maximum of $50,000, and it goes without saying that that particular person will not be permitted, all right, and to act as a financial advisor representative. MAS will simply refuse to enter his name in the public register, right? Or if it has been appointed, then upon discovery of the omission, then MAS may revoke the appointment. Okay. Of course, 17.2, again, in terms of the balanced regulatory approach, Section 23L4 provides that a person referred to above, right, that means guys who provide false or misleading statement or omission to state any material matter, well, shall not be guilty of an offence if that person can prove that he made all inquiries that were reasonable in the circumstances. Now, this refers to the principals. Right? If the principals have made all inquiries, reasonable inquiries, all right, and yet they missed out something, then it will not be an offence. Of course, the burden of proof will be on the financial advisor corporation or on the principal, right? And after doing so, believe on reasonable ground that the statement made or omission to state the matter or thing that was not false or misleading. All right? So first, of course, has made all inquiries, all right? So nothing come to light or nothing significant come to light. And after doing so, the principal have reasonable ground to believe that they are not material or they are not false or misleading, right? So again, it gives a way out to the principals in that regard. Okay. And it may also apply to the representative, the proposed representative, especially the provisional representative, himself or herself, in that regard, right? Now, the last point there, paragraph 18 on chapter 2, is in terms of appeals, all right? So any person who is aggrieved by the refusal of the MAS to enter his name in the public register or to enter an additional type. Now, sometimes an appointed representative may want to add on another type of financial advisory services or product in the register, right? So anybody is aggrieved by the MAS, the refusal to enter his name of other particulars, etc., or the revocation or suspension of the status. MAS, as you know, has the power to revoke or suspend the status of a natural person as an appointed or provisional representative under that particular section. Then this aggrieved person may within 30 days, all right, after it's notified of the decision of the MAS, appeal to the minister. All right. So if that person is aggrieved by the refusal of the MAS, then he has 30 days, all right, to appeal against the decision going to the minister. Okay, of course, the minister's decision is final. Right. So again, this is another example of the balanced approach of the MAS. Right, you are aggrieved. Well, you have a way to appeal the decision. All right, you can ask the somebody outside or somebody higher up to review and to to decide on whether the decision of the MAS is correct or not correct. Okay, that covers very quickly chapter 2. I've done chapter 2 already, so how? May continue? How? May continue? How? May continue? How? May continue? How?